This is Duke University.
So it's wonderful to have you here again this year. Last year you taught, and apparently it wasn't too frightening an experience, and so you're back again this week. And it's wonderful to have you here.
It's a very pleasant experience for me, so I'm happy to have the opportunity to be back here.
So Justice Alito, you were appointed by President George W. Bush in 2005 and confirmed in 2006, and I think you said, maybe quoting Justice Scalia in one of your interviews I read, that you said that when you were sort of greeted by, I think it was Justice Scalia, it sounds like him, that he said something like, you'll spend the first 5 years on the court wondering how you got here, and you'll spend the rest of the time wondering how everybody else got there. And so you're almost at the 5-year mark, and I'm just wondering how you feel.
Well, there's this sense in which I still wonder how I got there, and I suppose I will always wonder about that in a certain way, because it is largely a matter of luck. So I'm grateful for being lucky in that respect. I never have really wondered how my colleagues got there. They are very talented people. And they were also lucky to get appointed.
Good. I think somebody leaned against the light fixture, which makes things kind of exciting. Well, we're going to talk a little bit about how you got there, or at least one vision of how you got there. So, if we could, let's start with your growing up, and I don't know. Would you just tell us a bit? You're from New Jersey, and your folks and sort of what difference you think it might make to any judicial officer, really, the sort of formative period of their life?
Well, as you mentioned, I grew up in New Jersey. I grew up in Trenton, which is obviously the state capital, sort of between New York and Philadelphia. Both of my parents, by training, were public school teachers. My mother continued to teach until the very last day when they forced her to retire. She loved that job. And my father taught high school until the early 1950s, and then he became the researcher for the New Jersey legislature. In those days, the legislatures did not have big staffs like they do now, so he was the researcher for both the Democrats and the Republicans, and continued in that for the rest of his career, about 20 years. Of course, the staff grew enormously during that period. What effect does the place where a person grows up have on his or her thinking about the law? That's kind of hard to answer, but inevitably, we're all a product to some degree of our backgrounds, and we learn certain things as a result of our personal experiences, and that can't help but play some role in our thinking. It's good when people who have different backgrounds, personal backgrounds, different legal careers, are able to exchange their ideas on a multi-member court. I think that when that happens, then the product of the court can be greater than the sum of the parts. We can learn a lot from each other.
Do you think it's important to maintain a balance between, let's say, the American League and the National League on the court, between the Phillies and, let's say, the Yankees?
No. There've actually, and I have evidence to support that. There have actually been psychological studies of people who have grown up rooting for winning teams, winning sports teams, and people who've grown up rooting for losing sports teams. Now, when I became a baseball fan, a Phillies fan, as I said, I was in Trenton, which is between New York and New Jersey, and it was a matter of free choice. I could have been a fan of the Yankees, who in those days in the 1950s, as today, win all the time, and the Phillies, which is now a very good team, but in the 1950s they lost all the time. And for some reason, I chose the losing team, and I think it had a big effect on my thinking. It's similar to Chicago.
Yes.
There's a book. There's a book called Your Mind on Cubs, and it substantiates the fact that if you grow up rooting for the Cubs, it makes you smarter, more balanced, a more critical thinker, more realistic in your expectations about life.
There you are. I think I know this, and I don't think you would mind revealing it to this audience, that you actually have a baseball card.
I do, yes. In 1994, my wife, as a Christmas present, arranged for me to go to the Phillies fantasy camp for a week. And so I went there and pretended to be a baseball player with a lot of other middle-aged guys. And
You didn't get hurt?
not seriously. By the end of the week, we played each other. We played games against each other during most of the week. But for the final game, we played against retired major leaguers. And by that time, the locker room, the smell of Bengay in the locker room was overwhelming. And every single person, every single fantasy camper had pulled their hamstrings. So nobody could really run. Everyone was hobbling around the field.
So let's just fast forward a little bit through law school and then into the time when you went to work at the Department of Justice, and you had a very distinguished, interesting career in the department as a young lawyer. Why don't we start with your time as an assistant U.S. attorney? Well, first of all, what inspired you to want to do that?
I had been a law clerk for a judge on the Third Circuit, Leonard Garth in Newark, and I just loved that experience. And I thought at the end of the clerkship, what can I do that is most similar to what I did for this year? I was very reluctant to leave, and there was an opportunity to work in the appellate division of the U.S. Attorney's Office in New Jersey. The New Jersey office, unlike most of the U.S. Attorney's offices in the country, has attorneys who specialize in appeals. So this allowed me to work on appellate cases in a different role, and that was what I did initially, and that was really the first thing that attracted me to that position.
And so was that only appellate work at that point?
It was almost only appellate work. Sometimes we were asked a lot. We were sort of the legal experts of the office, so when issues came up during trials and the trial attorneys were doubtful about the answer, then something was very important. They would come to us. Sometimes the U.S. attorney would come to us for advice about things that were going on.
And then you went from there to Washington.
Yeah, I was briefing and arguing cases in the Third Circuit for about 4 years, and we worked with the Solicitor General's office because whenever we wanted to take an appeal, or we wanted to file a petition for rehearing, or we wanted the government to take one of our cases to the Supreme Court, all of that has to go through the Solicitor General's office. So we had a working relationship with them, as does every U.S. Attorney's office in the country. And I applied for a position with the Solicitor General's office so I could move from the Court of Appeals work to Supreme Court work.
And could you describe that a bit, the experience of working for the SG?
Well, it was a wonderful experience. I had the chance to work with some incredibly talented lawyers, two great solicitors general, Rex Lee and Charles Freed, and the career lawyers in the office, some others who came in for a shorter period, like Paul Bator. It was a tremendous learning experience. It was kind of a daunting experience to argue initially in the Supreme Court. I had argued dozens of appeals before the Third Circuit, but I still remember when I argued my first case in the Supreme Court, it was probably the most insignificant case the court heard at any time during the 20th century. But I still remember when I stood up to argue, when I was wearing the morning suit that government attorneys traditionally wear in arguing before the Supreme Court. I was extremely nervous about this, and a bit of time went by before there was a question. I was very grateful that Justice O'Connor asked the first question, and it was a very gentle question. It was when I knew the answer, and that sort of got me rolling.
Now that you're on the other side of the podium, so to speak, do you ever reflect on your time as a young?
Yeah, I do. It's a whole lot easier to ask questions than it is to answer questions.
So maybe now it's your role to throw a softball to a new young SG.
I would do that if I can get a word in edgewise.
Well, we might come back to that because that's an interesting topic. So you were in the SG's office for several years.
Yes.
And is there, aside from the most insignificant case of the 20th century, is there any other case that might stand out in your mind that was of particular?
Yes. There was the FCC versus League of Women Voters, which was a case that I lost and deserved to lose, but it was a good experience in retrospect. It involved the constitutionality of a federal statute that prohibited editorializing by public television or radio stations. And this statute was, everyone viewed it as of questionable constitutionality from the beginning. In fact, the Attorney General Civiletti had declined to defend it, and usually the Department of Justice will defend the constitutionality of any act of Congress that's challenged. The standard is that they will decline to do that only if they think that there's no professionally responsible argument that you can make in defense of the statute, or any reasonable argument you can make in defense of the statute. Then when William French Smith became the Attorney General, he thought it was really our responsibility to defend the statute. So that was our job, and I worked on the brief for the case with Paul Bator, and Paul was going to argue. He was a very, many of you may know of him, but he was a very distinguished scholar who taught at Harvard and other law schools before he came to the SG's office. And then there was a death in his family right before the argument. So literally 2 days before the argument, the Solicitor General said that I was going to have to argue the case. So in a way it took a lot of pressure off me. And I thought the argument went pretty well. I think we got at least 2, I think maybe 3 votes. So I considered it a moral victory, and probably was the best possible outcome, because the statute probably should not have been sustained.
So from the SG, then you went to the Office of Legal Counsel.
Yes.
And maybe you could just describe a bit what that is. I think most people know the Office of Legal Counsel now because of the opinions during the Iraq War.
Yes. Well, it was much less high profile in those days, but it's always performed a very important role. It provides legal advice for the Attorney General and for the rest of the federal government in matters that are not in litigation. It has taken over, in effect, of the legal advice function of the Attorney General. Once upon a time, the Attorney General would issue opinions on legal questions that affected the federal government but were not involved in cases in the courts. But the Attorney General personally doesn't do that very much anymore. It's delegated to the Office of Legal Counsel. So if there's a question about, or the President has a question about the constitutionality of a statute that has been passed by Congress and wants to know whether he should veto it on constitutional grounds, we would provide an opinion about that. Sometimes, more often than you might think, there were disagreements between components of the executive branch, different departments, different regulatory agencies about a legal question, and one part of the executive branch can't sue the other part in court to see which one is right, so they would present their arguments to us, and we would decide what the outcome was going to be for the executive branch. Involves a lot of separation of powers issues obviously about executive power. So it can get into some very controversial things, but during my time there, most of what came before us was not of that type.
I mean, it's interesting when you think about the Department of Justice, at least in my experience, with the experience that I had as a U.S. attorney, was that when you're talking about the prosecution function, the department is, I would say, virtually entirely removed from the play of political forces, and those would be resisted, I think, I think you agree with that. In other words, the White House does not weigh in on whether somebody should or shouldn't be prosecuted, and that would be viewed as perilously close to obstruction of justice or something of the sort. But when you get into these questions of, let's say, legal policy, and now you have a White House counsel's office, which seems to have a very different role. Let's say it's acquired a different role over the past 30 years, 40 years than maybe it had previously. That's a place where the department does become a player or a force or a factor in policy making, and I suppose it's more subject to compromise and pressure and negotiation.
Yes, no, I think all that's fair. The president, after all, has the responsibility to take care that the laws are faithfully executed. So the president has a law enforcement. He has the law enforcement responsibility for the federal government, and there are many areas in which it's entirely appropriate for the president, through whoever in the executive branch he wants to entrust that responsibility to express a view about legal matters. Now, there are areas where it is regarded, I think quite correctly, to be improper for political considerations to factor into the decision, and criminal prosecution, I think almost everyone would agree, is almost always in that category.
So from OLC then back to the U.S. Attorney's Office, how did that happen?
Well, I had always wanted to go back to New Jersey, and my wife wanted to go back to New Jersey. She had lived there during high school, and I loved working in the U.S. Attorney's Office. I learned that there was going to be a vacancy in the position, so I threw my hat in the ring for that position.
So you were the U.S. Attorney then?
Yes.
And running a very substantial office.
Yeah, in those days, I think we had 65 attorneys. Now, I think they have more than that. But it was a big operation to run, a very satisfying job. I know you must feel the same thing.
I think we overlapped a little bit.
I think we did, yes.
And then you were appointed in 1990, as was I. But you were to the appellate bench.
It's a vintage year.
It was a great year. So did you get a phone call from President Bush?
I did.
Yes.
From the first President Bush. He called me from Air Force One, and I thought the connection was surprisingly good.
One of my colleagues said that the president talks to idiots all day long because all they can say is, "Yes, Mr. President, yes, Mr. President." I didn't actually get the phone call, my wife did, but that's another story. So, and that call was to put you on the Third Circuit, where you had been a law clerk.
Yes.
And where you had practiced so much of your life. That must have been a very wonderful time for you.
It was. It was a little strange at the beginning because many of the judges who were on the court when I was clerking were still there. So I had my first relationship with them was law clerk to judge, and then I was appointed, and we were both judges. And it was particularly strange to sit on a panel with the judge for whom I had clerked. I think he sort of thought that I was still going to write him bench memos about the cases. But they treated me very well, even though some of them had 20, 30 years of judicial experience, and I had a few days of judicial experience. They really treated me as an equal from the very beginning.
So you were quite young going on that court. Were you at all hesitant about becoming a young judge, knowing that maybe this would be what you would do for the remainder of your career?
Yes and no. It wasn't. None of the jobs that I've had have been really planned. I didn't sit down at some point in law school or shortly after law school and say, I'm going to do this for a certain number of years, and then I want to do this, and then I want to do that. It's been sort of what's the best thing to do next. But the opportunity in 1990 was a golden opportunity, and I realized that it would very likely that would never come around again. For one thing, I'd never been involved in politics at all, and usually to be appointed as a federal judge, you have to know a senator or somebody involved in politics, and I didn't have that. I didn't have that benefit at all.
You had, I think, 15 years in the Third Circuit. Can you kind of evaluate that time for us? I'm sure it was a great time of personal growth for you.
It was. I loved that job. I had great affection and great respect for all my colleagues on the Third Circuit. The job of a Court of Appeals judge is a very difficult job. In a lot of ways, it's harder than being on the Supreme Court. The amount of work these days has reached crushing proportions. You can never escape work. The number of cases is incredible. We had about 300 per active judge, and that's much lower than some of the other circuits. On the Ninth Circuit, for example, they now have more than 500 cases per year per active judge. So if you think about trying to do a decent job on that many cases year in and year out, it's really, it is really a challenge.
If let's suppose that you had not been picked for the Supreme Court, would you do you think looking at it you would have been happy to think about living out your life on the Third Circuit?
Yes, no, I'm pretty sure that's what I would have done. I was next in line after our mutual friend Tony Sirica to be the chief judge of the Third Circuit, so I probably would have assumed that responsibility, and I'm sure my colleagues there are happy that they didn't have to deal with that.
We might just talk about that just for a second, because probably most of the people, students in the room, don't really realize what the role of a chief circuit judge is and how important that is.
Well, the chief circuit judge is in charge of all the administrative matters for his or her own court, to the extent the other judges let the chief do those things, and also has a lot of additional administrative responsibilities, many of them not particularly pleasant, and many of them pretty delicate. So it takes a lot of personal, it takes a lot of skill in dealing with people, dealing with the General Services Administration, for example, which runs all the federal buildings, and the chief judge has to write an opinion in every case in which someone files a complaint about, an ethical complaint about a judge. And you might be surprised by the huge number of complaints of that nature, almost all of which are completely frivolous, but still they all have to be examined. So it's a lot of work and a very delicate job.
So when the President Obama was making his last appointment here of Elena Kagan, there was a lot of discussion about whether it was good to have a Supreme Court entirely of judges who'd come through the circuit courts, or to have a mixture. And I won't ask for you to give an opinion about that unless you like to, but in terms of the preparation for being on the court, I'd be interested in that.
Well, there have been many very distinguished justices in the past who were not previously lower federal court judges. That's kind of it has been a recent trend. It's interesting to try to figure out why that's happened, and I don't really know that I have a particularly good explanation. I will say that I think it would be very difficult to go through the confirmation process successfully these days for anybody who was not either a federal court of appeals judge, or maybe a state Supreme Court judge for justice for a lengthy period of time, or a law professor who taught constitutional law and other subjects that come before the federal courts, or the Solicitor General, simply because you are expected on the day after the president announces that he is going to nominate you, you are expected to begin answering some very difficult doctrinal questions that are put to you by members of the Senate and by their staffs. And they take notes, and you go through a series of meetings with senators, and their staff members are writing down your responses to the question. So what do you think about stare decisis? What's your theory about how the Constitution should be interpreted, and things like that? And if you haven't thought through all of those things, or if it's been a while since you've done it, let's say you were a very successful business lawyer for a lengthy period of time, it would be tough. It would be very tough.
So I think that might lead us to the next topic. There are probably a few people in the room, particularly maybe in the faculty row, who think that someday the president might call him or her and say, I'd like to put you on the Supreme Court. But so Harriet Miers had been appointed, and then she withdrew. Maybe that's an example of what you're talking about, how difficult it is if you don't have that background. And then whatever you feel comfortable sharing, what happened next?
Well, at that point, I thought that I wasn't going to be nominated. I had been interviewed a number of times. I was first interviewed this is all public record stuff at this point, back in 2001. And I think these days, any incoming president probably asks somebody on his staff in the White House counsel's office or in the Justice Department to begin putting together a list of potential Supreme Court nominees, because it's predictable that there will be a certain number of vacancies during a 4-year term or an 8-year term. And once a vacancy occurs, sometimes they come up as a surprise. There may not be that much time to come up with a nominee. So I think usually they work ahead. So I'd been interviewed a number of times. And when Harriet Miers was nominated, I thought, well, my chances have gone by. And I was very surprised to get a call after that to see whether I was still interested, and I said,
no, I think I'll take a pass.
I said that I was, and they do a lot of full disclosure before they get an answer from you, and they say that it's going to be pretty brutal, and are you willing to go through that?
And then do you eventually meet with the president and the job is actually offered? Is there a point of sort of offer and acceptance?
Yes. Well, I had been interviewed by the president earlier. I think presidents these days tend to do that personally. It was a fairly detailed, lengthy interview. Then when I initially got the call after Harriet Miers withdrew, that was I got a couple of calls from members of the president's staff. Then the president personally called, and I had already told the staff, yes, I'd be very happy to accept. And he said, well, I'd like to nominate you. And I said, well, Mr. President, this was the talking to fools business. Yes, Mr. President. Yes. I said I would be very honored. And then there was kind of a long pause, and he said, well, does that mean that you accept?
So a contract scholar wanted to be sure. So then that begins this ritual that we now have, sort of our version of bear baiting or something like it, known as the Supreme Court confirmation process. Yes. Very exciting for everybody. And it's been some years now, but do you have any sort of reflections on it?
Well, it was a bizarre process for me, a bizarre experience for me, because the job of a Court of Appeals judge, which I've been doing for 15 years, is about as isolated from the glare of publicity as you can get. My days consisted of driving to the office, walking up to my chambers, reading and writing, talking to no human beings except my assistants and my law clerks, getting back in my car, driving home, and doing the same thing the next day, reading and writing. Every once in a while there'd be an oral argument, maybe every 6.5 weeks, but once I was nominated there, and this always happens now, there's an enormous amount of publicity, and it gets to a ridiculous extent. I immediately began having meetings with senators, as I mentioned. In the end, I think I spoke to 83 senators. So for more than a month, every single day, my day consisted of going to the White House, and then we would drive over to one of the Senate office buildings. And as soon as we got out of the car there would be reporters constantly snapping photos, still camera people, and then people with video cameras and very sensitive boom mics that they were always sticking in your face. Then you would go into a meeting with one of the senators, and initially all these photographers would come in and they'd have the mic stuck in our faces. So we would talk about something non-controversial with the senator. That was a little difficult, a little strange. And then they would leave. Then we get down to business of the interview, and that continued for well over a month. And then I began.
So in those interviews, the senator would actually ask you questions about law or legal policy or that kind of thing?
Oh yeah. Very detailed questions about doctrinal issues. They would not ask how would you decide a certain issue or a certain case, but general questions about how you interpret the Constitution, how you interpret statutes. Sometimes they would push to try to get you to provide hints at least about how you would decide certain issues. Because I had been a judge for a long time and had issued a lot of opinions, then I was questioned in very great detail about some of those opinions. Maybe about 30 or so opinions just kept coming up over and over.
And then so that's a month of going around, and then you have to start the preparation process probably for the televised hearings themselves.
Yeah, and we had practice sessions, quite a few practice sessions, where various lawyers pretended to be senators and tried to simulate the asking of questions.
You were being mooted.
It was exactly like a moot court. We even had one session to simulate the length of the longest session that was anticipated. I don't know whether they did this with Justice Kagan, but for Chief Justice Roberts and me, there was one day where I think we started at 9 o'clock in the morning and we went until something like 8 o'clock at night, constantly, with just maybe an hour or so break for lunch and dinner. So one of the main points of this session was just to simulate what it would be like to be answering questions for that length of time without losing your concentration and saying something that you regretted saying afterwards.
I don't know whether you would feel comfortable expressing an opinion on it, but if one could change the process, or it seems to have some very considerable potential value to it, which is that it's sort of this opportunity to have a national discussion about legal policy, and of course the country is extremely interested, and that's important, and one would want to encourage it. On the other hand, some of what you describe, the atmosphere seems off in a way, too politicized. But it's, we are where we are in our history.
Yeah, and this is something that's going to have to be worked out between the President and the Senate, whoever the President is, at times in the future, whoever is in the Senate. The Constitution divides the responsibility for judicial appointments between the President and the Congress. The President appoints by and with the advice and consent of the Senate, and the Constitution doesn't precisely define how that responsibility is to be divided, and at various times it's shifted in one direction or another.
So when you become a Supreme Court justice, I suppose you have to decide sort of how to organize your chambers and whether to belong to the cert pool or not belong to the cert pool, and generally how you're going to prepare yourself. So what kinds, how did you resolve those questions?
I initially started by doing essentially what I did on the Court of Appeals. The work on the Supreme Court is in some ways very similar to work on the Court of Appeals. About 2/3 of our cases come up through one of the federal courts of appeals. So they're not unlike, they are cases that I could well have sat on in my old job. There are some very substantial differences. But I began by doing things pretty much the way I had done them before. The aspect of the job that was most new, completely new, was all the cert work. On the courts of appeals, as you probably know, almost all the cases are appeals by right. And on the Supreme Court, it's exactly the opposite. These days, the vast majority are discretionary. They're cases in which we grant cert. There are not that many cases each term in which a party has a right to take an appeal to us. We now get, I think, around 9,000 cert petitions a year. So that's and it's very important to do a good job in picking the cases that we are going to hear. So that's a very substantial part of my current responsibilities that doesn't have an analog in what I did before. And you mentioned the cert pool. I was in it initially, and that's you may or may not know what that is, but when I started, 8 of the justices were in the cert pool, including me. Justice Stevens was not. And we all contributed, our 4 law clerks, to a pool, so each case, each cert petition was assigned to a law clerk who wrote a memo for all of the justices in the pool, and that was a way of getting a handle on what was before us. And I think it serves an important function, but after a few years I decided that I would prefer to get out of it and look at the petitions directly without having them filtered through the cert pool initially. And I'm out now. Now I'm the only justice who's out, and it's my plan to continue to do that for at least the foreseeable future.
So do your clerks then write you a short memo on each one of the 9,000 cert petitions?
No, they look through all of the 9,000 cert petitions, and they pull cases, petitions that they think I should pay particular attention to. They write memos on some cases that fit certain criteria or jump out at them as cases that require that merit more attention. We talk about those cases as well as others orally.
Did justices, when they're looking at these 9,000 cases, did they ever say, you know, there's this legal issue out there that I've been very interested in, and I've been watching it over time, and I'm looking for a case because I'd like to address that issue again? Or do they, which is, let's call it strategic behavior maybe, or do you just sort of let the game come to you?
Well, for the most part, the game comes to us. We choose the cases that we take, but we don't choose the menu of cases from which we make our selection. So the cases that come to us via cert petitions are chosen by the attorneys who choose to file those petitions. There are issues that it's not uncommon for us to decide a case and see that our decision in this particular case leaves open other important related questions. And so I think we make a mental note, I at least do, about that. And then when a case comes up that provides the opportunity for answering some of those questions that were not decided or not resolved satisfactorily or completely in the prior case, then that case may be a good case to take. Or we may see an important decision that seems questionable by one of the courts of appeals, but there isn't any split in the circuits at that point. And if it's an issue that we think will come up in other circuits, we will often say it should percolate. I don't know that anybody percolates anything anymore other than cases, but that's kind of the terminology.
I think groundwater, maybe. let's talk about the life of a case a bit. Let's say that the cert petition comes in and the cert pool is circulating a memo on it, and let's suppose the law clerk who prepared the cert pool memo is recommending a grant. And do you get the memo as well? Is that no? Okay, so you don't even know what the cert pool has done, but maybe your law clerks do. And so and let's say they've also recommended to you, and the court grants cert, which takes 4 votes, and so the case is set for argument. Then what happens in your chambers at that point?
Well, let me just add one thing about seeing the cert pool memo. If a case is listed for discussion by one of the other justices, we don't talk about all those 9,000 cases, or we would never do anything else. So we talk about any case that anybody wants to talk about, any of the 9 of us. If any of us put the case on our discuss list, then we will discuss it. So if a case is put on the discuss list and it's not readily apparent why someone else may have thought that this was the case that merits discussion, then I will look at the cert pool memo, because often that will provide a clue about why the case was listed. But once a case is listed, then we vote at conference. It takes 4 votes to grant. Once the case is granted, then I wait for the briefs to come in, and when the briefs come in and the cases are set for one of our oral argument sessions, my law clerks divide the cases up among themselves. They write a bench memo for me, and then at some point before the oral argument, we will all sit down, all 4 clerks and I will sit down, and we will talk, usually in considerable depth, about each of the cases that's coming up for oral argument. And then after the argument, we will talk about the case again, going into the conference. After the conference, I'll go over what took place at the conference, and then at the end of each 2-week period, the opinions for that argument session are assigned. Usually these days there will be 12 cases argued during a 2-week argument session, so we will each get 1 1/3 cases per argument session, and then when an opinion is assigned to me, the clerk and I will work together to try to put together a pretty detailed outline of what the opinion should say. Often I will work up an outline first, and then the clerk will make it more detailed, and we'll go back and forth on that until we have a pretty good idea about the argument, the structure of the argument, the authorities we're going to use, and so forth. Then the clerk will do a draft, and then I'm a very, very fussy editor, so I will then take that draft and usually just sit at the word processor and change it, rewrite it. But that I found to be the most efficient process. It makes sure that the opinion, when I get a draft opinion, it says what I wanted to say, and then the editing, if things go well, the editing can be largely stylistic, except that for some reason, whenever I get to the point of writing an opinion, actually going through it sentence by sentence and word by word, no matter how carefully I've studied it up to that point, new thoughts come to me. That when you're really immersed in writing something like that, you see things that I see things, or I think of things that I didn't see before. So unfortunately, that often requires a lot of rewriting, sometimes reorganizing, which is not particularly efficient, but sometimes necessary.
Does the chief, when he assigns cases, or whoever is assigning the case, it might be the senior justice in the majority, do you get a deadline of any sort or an expectation of this case will be circulated within the next 3 weeks, or is it just entirely up to you?
We don't have any deadline like that, except there are a few rare cases where there's some special reason why an opinion has to be produced quickly. But the expectation is that the opinion will come out within a pretty reasonable period of time. And one of the things that we do during every conference is go over We go over all of the outstanding opinions, all of the opinions that where a draft has been produced, and we see where we are. Is there going to be a dissent? Who's going to write the dissent? Is there going to be a concurrence? How many people have signed on to the opinion?
So it's justices often say that every time there's a new justice, a justice leaves the court or a new justice comes to the court, that the court changes entirely. And I think I've said to you, I find that a bit hyperbolic, but there's obviously some considerable truth to it. You know, you've now in the relatively short time that you've been a justice, there have been 2 new justices, and I'm wondering if you have any reflections on that principle.
Well, I think that there's some considerable amount of truth to the statement that whenever there is a replacement of a justice, it changes the court. Obviously, in some instances, it changes votes, but even if it doesn't change that many votes, of course, you never really know, but it certainly can change it inevitably changes the dynamics, the internal dynamics of the court, because everybody has a different personality. Everybody does things differently and relates differently to other people. So it inevitably does cause changes. And I anticipate that the latest change will have a considerable effect on the court because Justice Stevens was on the court for such a long period of time and had such a wealth of experience on the court, was the senior associate justice, so he very often had the responsibility for assigning majority opinions when the Chief Justice was not in the majority. He was not in the cert pool. At the beginning, as I mentioned, of my tenure, he was the only justice out of the cert pool, and he continued to be out of the cert pool. So that, as a result of that, he played a special role in the process of putting cases on the discuss list and thereby advancing them on the court's agenda as candidates to be taken. Now, I'm sure Justice Kagan will do a fine job and will bring her own particular skills to the court, but still, it's a different person, so it's going to make a difference.
When you're getting ready for the oral argument, do you formulate a couple of questions that you're pretty keen on asking?
I try to think about questions that I would like to have answered. I often try to think about the weak points in the arguments for each attorney and try to ask about those if I can, if one of my colleagues doesn't do that first. But that's one of the main functions of oral arguments. When you're writing a brief and you come to a point that in your argument that's weak, you can write around it. You know, you can pass it over quickly, or you can try to think of some clever thing to say and move on to the next point without dwelling on the weakness of your argument. That's your job as an appellate advocate. If you have a great answer to an objection to your argument, then obviously you want to make it. But if you don't have a great answer, you have sort of a weak answer, you tend to downplay it. But you can't get away with that at oral argument. You can be pretty certain that will be a focus of questioning.
And how do you get a word in edgewise?
Well, I learned that I started out by thinking I should try to wait until the lawyer sort of finished a paragraph, and that was a disastrous strategy. So then I went to the end of a sentence, and that was not particularly successful either. So you have to be a little bit rude. It's a very strange format. If you've participated in moot court or you've seen moot courts, you know what I'm talking about. But elsewhere, outside of the appellate arguments in the law, there's no other place, I think, that has this format where somebody stands up and starts to talk, and then a lot of people start interrupting in the middle of a sentence and asking questions.
So last term was you did a lot of writing, and the McDonald, you wrote the majority opinion in McDonald, and I wonder if you'd just be willing to describe the issue there and how you tackled it.
Yeah, it was a very, very interesting case, very well briefed. It was a case with an enormous number of amicus briefs. These days, although people chide us about the reduced number of cases that we hear on the merits, the total pages of briefing that we receive has increased enormously. In McDonald, it must have been over 500 pages of amicus briefs. But anyway, McDonald was a follow-up, in a sense, of the Heller case from a couple of terms ago, which held that the Second Amendment protects an individual's right to keep handguns in the home for self-defense. It involved an ordinance of the District of Columbia, Heller did. So there was no question, we didn't have to face the question of whether this same rule applies to the states through the 14th Amendment. And that was the issue in McDonald. McDonald involved ordinances of Chicago and a Chicago suburb. The case was, the attorneys for McDonald and the other petitioners chose to argue the case in a way that would have had very broad implications extending well beyond the Second Amendment had their particular argument been accepted. They argued that keeping and bearing arms is a privilege or immunity of citizenship of the United States. So this would have involved overruling the court's decision in the slaughterhouse cases from the 1870s. Since that time, the Privileges and Immunities Clauses played a very small role in constitutional law. So this would have been a real sea change in the law. What the court has done beginning around the end of the 19th century and continuing and accelerating really in the 1960s was to, and those of you who've had con law know all this, but this was like a refresher course in con law, this case, to incorporate most of the protections of the Bill of Rights into the Due Process Clause of the 14th Amendment, and they were made applicable to the states through that process. And that's what the court ended up holding, that the Second Amendment right, like almost all of the rights in the Bill of Rights, is incorporated into the 14th Amendment and therefore is applicable to the states. It was a case in which stare decisis and what one might think was the original meaning of the 14th Amendment were in some tension, because there are a lot of scholars who believe that the slaughterhouse cases were wrongly decided, that the Privileges and Immunities Clause was the provision of the 14th Amendment that was intended to provide substantive protection against infringement by the states, and that the idea of incorporation through the Due Process Clause is not at all what the 14th Amendment was intended to do. But that's the path that the law had taken. And what we did, what the majority, the majority held that the right applied to the states. The plurality view was that it did so through the Due Process Clause. Justice Thomas stuck with what he thought was thinks is the original meaning of the Privileges and Immunities Clause, and relied on that.
So it's a good case for seeing how the different justices have different approaches to constitutional interpretation, I suppose.
Yes. Justice Thomas was a purist on this, and he said, "This is what I think the Privileges and Immunities Clause means, and I'm sticking with it." And the plurality thought that we should, at this point, we were committed to continuing along the incorporation route, and that's what we did. And then there were 4 justices in dissent. Justice Breyer's dissent, I made a very strong argument that I said, in my opinion, really called into question the whole doctrine of making Bill of Rights provisions applicable to the states. And he argued that this is a big, diverse country, and different states, different cities may want to have different rules about gun control, and the country benefits from People in different localities have different values. The country benefits from experimentation. There shouldn't be a single rule that applies everywhere in the country. It's a very strong argument, but it's exactly the same argument that was made when there was an issue about incorporating other provisions of the Bill of Rights, all the ones involving criminal procedure, for example. There are different ways in which various things could be done, but in all of those areas, the court had adopted a national rule, and the opinion of the court said we ought to continue along that path.
You wrote two dissents this year that caught my eye. One you were alone on, and that was the Stevens case that involved a statute that made depictions of animal cruelty illegal or prosecutable, and you were alone. Maybe you and your dog. The court, and I'm wondering how does that feel when you're, it's 8-1. Does it cause one to pause?
No, because I was sure I was right. I'm still sure I was right.
Yeah.
Harry Truman is quoted as having said, I don't know whether he actually said it, that if you want a friend in Washington, get a dog. And if he didn't say it, he should have said it. And my dog is my friend. And late at night when I have trouble deciding cases, I talk to him. He always agrees with me. But on this case, he was very persuasive.
An amicus brief.
So I couldn't betray him.
Well, I know that's a difficult area of the law. The Christian Legal Society case was another, I think, interesting case. Probably be interesting to law students since it involved a law student association.
Yes.
And there, again, you were in dissent, and there was a debate within the court in a way, as to what had actually happened.
Yes. Well, it presents, I think, a very important legal question, and the question has to do with allowing the expression of diverse views on a public university or law school campus. The court has held that if a public educational institution creates what's called a public forum by, for example, recognizing a great many student groups and providing certain benefits for those groups, maybe office space or the ability to use email or maybe some modest funding or a bulletin board where things can be posted, things of that nature. If it creates a forum like that, it can't discriminate on the basis of viewpoint. It can't say we're going to allow the Republican club to say what it wants, but we're not going to allow the Democratic club to say what it wants. We're going to allow the Christian group to say what it wants. We're not going to allow the Jewish group or the Muslim group to say what it wants. The court has said that. I think it's very important. I think that really goes to the heart of the First Amendment. And protecting First Amendment rights, I think, are particularly important on a university campus, which is supposed to be dedicated to debate, open debate about ideas. The Christian Legal Society case, I thought, presented that issue with respect to the Hastings Law School in California. But the way the case was litigated in the lower courts caused an element of confusion because there was a stipulation at one point that Hastings had a policy of requiring every registered student group to accept anybody who wanted to be a member of that group. That stipulation was interpreted by the court to mean this was Hastings' real policy, and this was the policy that Hastings had actually followed. At least their decision, I think, was predicated on that assumption, and I thought the record disproved that. The record at least raised a question whether that was really Hastings' policy. So it became, I think it's a case that involves an extremely important free speech issue, but it became complicated by some confusion regarding what had happened in the lower courts.
Could you say a word about the course you're teaching, just what it is?
Yes, well, it's a course in which we look at, well, we begin by looking at some things that other justices have written in general on the question of interpretation. So the students are reading excerpts from Justice Scalia's book, A Matter of Interpretation, and Justice Breyer's book, Act of Liberty, and a few other things that justices have written. And then we're looking at cases as recent cases from the last couple of terms, not just to understand those cases themselves, but to look at, they provide vehicles for testing different theories of interpretation, strengths and weaknesses of them. They raise issues about stare decisis. Issues about how members of a multi-member court should behave in relationship to each other. Principally, how far do you bend in order to produce an opinion of the court, or maybe a unanimous opinion of the court? When do you write a dissent? When do you write a concurrence? If you do so, what do you say? For this year, a lot of it is material that I had in the course last year. I've also added a case, kind of a sleeper case, I think, from last term called Comstock, which dealt with the necessary and proper clause. And I think that's going to be something of importance in relation to some pending litigation that has gotten a lot of public attention. So I think it was a good opinion by Justice Breyer for the court, and I wrote a concurring opinion. Justice Thomas wrote a dissenting opinion interpreting the necessary and proper clause much more narrowly, or somewhat more narrowly.
You might be interested that we mooted one of the lawyers here at Duke before that argument.
Right, that was a case from North Carolina.
Yeah, exactly right. Well, let's see if there are a question or two, and then we'll call it an afternoon. Anybody? Yes?
Back?
Go ahead.
Sorry, at the worst seat in the house. But of course, it's a wonderful opportunity here just to speak, and I'm very grateful for it. And I was wondering that, Justice Alito, if you have any advice for a law student aspiring legal professional, as someone who's achieved probably the pinnacle in the public sector of the legal practice, is there a way, in your opinion, that you can best achieve a family and professional life balance and still be successful?
Okay, the question is, what about the work-life balance? How can you do that? How can you manage that and be successful as a lawyer?
Well, it's a really hard, it is a hard question, and I can't give you an answer that's going to be applicable across the board. But I do think it's something that you should all think about. The law is a very hard-working profession, as I'm sure you know, or you very shortly will know. You're generally expected to work very long hours, and that can, if you let it, that can crowd out much, if not all, of the rest of your life. So you have to decide. There are trade-offs between making a lot of money sometimes and having other things that are valuable, such as time with your family. The best I can say is that in deciding what you want to do, you should be clear in your mind that you are going to have to make. You can't have everything all the time. You have to make some hard decisions about how much of this one thing you want and how much of this other thing that you want. For me, a benefit of my position on the Court of Appeals was that I, for the most part, was able to set my own schedule. Although I had an enormous amount of work to do, I could mostly do it when I wanted to do it. So that allowed me to do things with my family. I didn't have that many scheduling conflicts. I would make up for that time by working at night or late into the night sometimes, or more often than not working through the weekend when I wasn't doing something in particular with the family.
Thank you. Let's take one more. Yes?
how often do the justices associate with one another when they're not in court? Like, how much do you guys socialize with one another?
Okay, so how, do the justices get together informally and otherwise?
Yes, we do. I see my current colleagues much more frequently than I did my old because on the Courts of Appeals you're spread out in different cities. Here we're all, during the course of the term, we're obviously all together in Washington during the weeks when we're hearing arguments and conferencing. And on those weeks, we generally have, on every argument day and conference day, we generally have lunch together. And we have a rule that we don't talk about cases during lunch. We talk about anything else. So we talk about sports. We talk about opera. Some of my colleagues are great opera fans, or things of that nature. And then there are other occasions when we get together. We really, I think, do a pretty good job of separating our intellectual disagreements we may have about legal issues and intellectual disagreements from anything personal.
So Justice Alito, the Phillies are very fortunate to have you as a fan, and we are very fortunate to have you as a teacher and colleague, and the country is very fortunate to have you as a justice. Thank you very much for being here today.
Produced by Duke University. Online at duke.edu.